Good evening. I'm Jen Jones, and on behalf of Illinois Families for Public Schools, welcome. We're very excited to share this time with you to talk about the new play and privacy laws that have been years in the making and align with our goal of improving Illinois public schools for all children. This evening's program will be split between play and privacy. We've put together a good overview of each, but if there's anything you'd like to know more about, please type a question in the chat. We'll try our best to answer them throughout the evening with a wrap-up Q&A at the end. Just a heads up, as Cassie said, if you're joining, we are recording this presentation to share on our YouTube channel, and I'll drop that link in the chat. All right, next slide. It's great to see familiar faces, but for those of you who may be new to our org, we started in 2016 as Raise Your Hand Action, a 501c4 sister org to Raise Your Hand. In 2019, we rebranded to Illinois Families for Public Schools to better reflect our scope of representing the interests of all Illinois public school families. Our C4 status allows us to work directly with legislators and lobby on public ed issues such as privatization, funding, standardized testing, and student privacy. Believe it or not, we're currently the only pro-public ed C4 parent voice on the ground in Springfield, which is one reason why we're so proud of what we accomplished this year. So let's get to it. It's my pleasure to introduce Samai Giwala, our Assistant Director of Organizing and Policy, who will take us right to the Right to Play law.
Thanks so much, Jen. It's great to be part of this amazing presentation with so many great guests. The Right to Play law was one of our signature issues this year, and it was one of something that we've been working on for a long time. Did we lose the slides? Okay, thank you. And it took a lot of work, and we really appreciate everything that went through to it. Next slide. It seems kind of obvious to a lot of people that play is something that should be in schools, but really there is more than just sort of a play and a break. It is learning, and it has been shown to have serious beneficial effects for learning, and even it's considered a human right across the world. Unfortunately, in the United States, we're seeing the opposite. We're seeing time for play being cut across the country in response to an increased amount of testing and educational technology. And schools just are looking for some way to make more time. And unfortunately, play and recess is easy to cut. So we are seeing it drop down to 0 in many places around the country. Next slide. So we know, and what we've been able to see is that there's 3 main benefits to play. It affects both the cognitive and academic side of things. It helps children learn. It allows brains to absorb what they've learned in the lesson. Physical, just purely physical health. We're seeing an obesity epidemic across the country, and free play just is something that children need. And then there's social and emotional. That's how children grow. That's part of learning as well, is to develop relationships, learn how to deal with situations. And that's something that we know is very neglected these days. And of course, it's cheap. It doesn't cost things. We don't need licenses for recess. It is what we all have done for years, and everyone knows about it, and it's self-directed. Next slide. So it seems self-evident that we needed recess, but unfortunately, a lot of schools didn't have it. There was no requirement at the state level. And then looking at most districts in the state, almost none of them had policies at all. Huge districts with Chicago has hundreds of schools, U46, hundreds. There was no uniform policy even across districts. It was just up to individual principals, and just rules were completely different from school to school, and really affected students of color and low-income students the most. They were the ones who were being denied play, and even when there was play in their school, it would be taken away as punishment, which is the worst thing to happen if you have a child who's acting out. To take away the play and force them to sit still just creates even more behavior problems and is the start of that slippery slope into the school to prison pipeline. We saw states outside of Illinois that had recess laws, and even a bare minimum of recess there would encourage schools to provide much more, 20 minutes or more in those 8 states. Next slide. So this has been a long fight. In 2004, Community Organizing Family Issues, COFI, started working towards bringing around play because many of those schools didn't have it and children were suffering for it. 10 different bills were introduced from 2009 to 2017. And Raise Your Hand got involved at the city level. And so a lot of groups in the city were able to get a 20 minutes of recess in CPS, but that really was just a start, and it was limited to just one district. So in 2020, we made a big push. We gathered a lot of allies, and we made it through this year. It was signed into law in August and immediately became effective. Next slide. So what is in the bill? The key thing is that schools must provide 30 minutes to every student from kindergarten to 5th grade of unstructured, self-directed screen time. And they cannot be excluded from that as punishment. And I'll go into it a little more detail in the next slide. We kind of have 2 major elements to it. It's 30 minutes a day of unstructured play. So you can have it broken up into 15-minute segments for like morning and lunch, for example, but you can't have anything more than or anything less than 15 minutes. And that does not include the time it takes kids to get ready to put hats, coats, gloves on, because in many cases in Illinois in the winter, it takes, by the time the kids have the hats, gloves, and all on, if you have 10 minutes of recess, then you already have to take it off. So that isn't part of play. Putting hats and gloves on is not the same thing as free play. So it has to be screen free. Kids can't be on their devices, and also the schools can't just herd the kids into the multipurpose room and put on a video. It has to be an unorganized activity that allows the kids to, use their imaginations, not have to follow orders, and it should especially be active. In a lot of schools, you should have outdoor if there's outdoor space available. Some schools don't have that, or there are safety concerns. So it should be in a space where kids are able to move around, in a gym or a multi-purpose room, or something where you're able to get a little physical activity. If not, then playing games or things is allowed, but strongly discouraged. And the thing is, not PE. PE is by nature sort of a directed formal activity. Recess is not. And so, we saw a lot of schools were actually just using recess time to cover their PE credits, but they're different things and they have different purposes. So you can't have, you have to have the 2 different physical requirements and have them be separate. And the next slide, we'll see that the other main part of the act is that play must be available to all. It can't be taken away as a punishment. Everyone deserves play despite any other activities. The only way play can be taken away is if the student poses an immediate threat to their own safety or the safety of others. Other than that, kids should be allowed to play as they see fit. If it's self-directed, then, allowing somebody to play by themselves is really what should be allowed. And of course, you need somebody in the area to make sure everyone's safe, but you can't just take it away, kick a kid out. And then the bill now mandates a student with disabilities must be accommodated. They can't just sit with their paraprofessional. They have to be allowed to play according to however their IEP or 504 plan is written. And then the next slide. The main thing is kind of just go in there. PE is not playtime. A lot of schools have been trying to fiddle around with that this fall, and it has to be pretty clear that they're two separate things. You can't withhold play. Students with disabilities can be in there. And the biggest thing is that lunchtime, like putting on the hats and gloves, it's not playtime. Lunch is a completely separate thing as well. Play needs to be what we all visualize as play. It's not lunch, it's not PE, it's the freedom to actually, act for yourself and, be self-directed. Next slide. So what's next is that the bill is in effect, has been in effect since the beginning of the school year. But a lot of schools are telling parents, oh, we need time to get it in. Oh, it won't apply until next year. But it's the law, it's right now. And so if you know people who aren't getting recess or their kids aren't getting recess, please go to our toolkit. It's on our website, ilfps.org/recess toolkit. It's in the chat. And please, we have a lot of resources. Get in touch with us because this is something crucial that kids deserve today. And the law, it's not a complicated law. It just needs to be implemented by schools. And we got a lot of pushback from superintendents and school boards because even this is apparently too much for them. So the pushback continues and we just need to keep fighting to make sure the kids get it. Thank you. And then the next slide, we got just a thank you for everybody who did this. This was a really tough fight. It took a lot of work in Springfield, a lot of negotiation, but we had a lot of supporters who came through. And we couldn't do without you, and we always need as much support as we can to make sure that crucial issues like this come through.
Thanks so much, Samai. It looks like we do have a question in the chat. Catherine Francis, one of our board members, is going to guide us through questions and answers tonight.
Sorry about that. So we have a question about a specific school that currently has 20 minutes outside, 20 minutes in the classroom, and 20 minutes lunch. And the question is this violating the law because of the 20 minutes in the classroom? Or what are the technicalities of, I know the 20-minute lunch is not included per your presentation, but.
This is, again, one of those weird things where schools are going to try and push the line as much as they can. It's kind of funny they accuse the kids of doing that, and here they are. So it is allowed. I mean, the key thing is that what are they doing in the classroom? Are they being like assigned an activity, or are they able to, just do self-directed play? I think that's the concern. And then, putting on the winter clothes, it has to be worked into the schedule. So this is something, I mean, it's kind of tough to put a stopwatch on somebody, but if it's clear that the kids aren't getting outside at all, then that's something that needs to be addressed. So, and I think it's a little ridiculous that they're forced to eat with winter clothes on. I mean, I lived in Minnesota. We had to do all sorts of stuff, but even then we weren't forced to put on our winter clothes and then eat. So I know it's not a really great answer, but
yeah, I'll
it
add
seems-
one thing. We've had other parents ask about this. One thing you can also share with your school is that the CDC recommendation and for lunchtime is that you should have 25 minutes of seated time to eat, which I think basically no schools actually manage to do, but I think it's something that you can advocate for. It's not required in the law or in even like guidance from the state, but that is the official guidance from the federal government that you should have 25 minutes to eat, and that's not counting your time in line. And I think just especially gathering some other parents who think that these sort of quality of life things are an important way to keep, to have a real nurturing school environment that actually is looking at the whole child, and whole children need to eat and play, is kind of what you have to do, because there's not really anything specific that's saying that any of that is not allowed. But especially if they can play outside, it's 20 minutes other time, you think that they could be doing it for both recesses. So yeah, we've definitely had people talk when we talk about this saying like, yeah, we need some regulation of lunchtime next. So, totally agree.
So I think I'll flip it back to Jen to talk about the next segment.
Thanks. Cassie, I can't see the slides. Are you going to pop them back? Great. Thanks so much. So we're going to switch gears and move over to student privacy, and our director, Cassie Creswell, will take us through the Student Online Personal Protection Act and what's new in that arena. Thanks.
So hi, everybody. I'm going to talk about a law that was passed originally in 2017 in Illinois, and then some major changes were made to it in 2019, but schools and districts had 2 years to comply. So it did not go into effect until this summer. So really in schools in Illinois, it's sort of a new law right now. And so the basic idea behind this law is that we need to protect student data. There's ever more data being collected because of the use of digital technology in schools, and there's ever more money and time spent on this technology, and that's generating a ton of data points about kids. Parents may know very little about what's being collected, what's happening with it. And unfortunately, even school personnel and administrators and school boards may not really know either. So, what data is being collected, how secure is it? If a breach does happen, what happens? Who has access to the data? How long is that data going to sit around somewhere in a database? What can it be used for in the meantime? And so all those questions are essentially, you need to have answers if you're going to keep data safe. So see, here's a little slow. So what does your student data contain? There's sort of kind of like what you think about when you think about student data, the academic aspect of things. So grades and test scores. There's also then personally identifiable information. So names, addresses, birthdays, social security numbers, student IDs. But because there's so much use of technology now, there's a whole lot more data too. So things like health information, not just say the list of vaccinations or medications that a school might have, but even something like heart rate, if that's being measured in gym class. There's behavioral information in sort of from surveys or from discipline records, and in apps that are things like Class Dojo, where they're really tracking behavior. There could be sensitive family information, things like foster care status or the years that you've lived in the US. Also just sort of the flotsam and jetsam digital stuff that's generated by apps, things like geolocation and IP address, even things like your food purchases in the cafeteria are probably stored as data, and then any kind of communication materials, emails, and that kind of thing. So there's just a ton of stuff. So why do we care about protecting this? For one thing, if there's a breach, breaches are really expensive to deal with. Breaches are actually pretty common. This GOA study that I cite here was just looking at a 4-year period and just looking at breaches that were officially reported to a government agency, like a US government agency, and found close to 100 that affected many thousands of students, and some really sensitive data was exposed for those. So things like grades or bullying reports and social security numbers. Data, even if it's not been shared in a breach, can be used in harmful ways. There's very few restrictions, for example, on how law enforcement agencies that collect data in schools can use it. And so here in Chicago, students have been added to the city's gang database. Those are some side effects of data that it's not because of a breach, but it's just how this data can be used. Longer term, all of this data can be used to restrict future access to opportunities like college or health insurance or loans. The term for that is called digital redlining. And that's really an issue as we collect all this data and it's sitting around long term. And all this increased collection means opportunities for increased surveillance as well. And there's really huge questions about how this is infringing on civil rights, not just of students, but of their families. So if there's apps that are, or software that's collecting basically, you know, your child's every keystroke and web history, even if they are not on a school device, it's not during school, they're not on school grounds. Some of that information is still being collected. We're hearing from families about that. And it is in some cases being surveilled. And in some cases, not even the student using the computer in that case, but it's a family member. So that's really a major question about the sort of privacy implications of data collection. So there's kind of 5 basic principles when you want to protect privacy. You want to know, you need transparency, so you know actually what data is being collected and who has access to it. Like I was talking about before, especially in the student realm, there shouldn't be commercialization. People shouldn't, these third-party orgs shouldn't be further profiting off their access to data. Security is an important part of protecting privacy, so making sure that the data is secure, and if a breach does happen, what are the procedures that take place? Are people notified? Are they given help in dealing with identity theft? Control means, do you have some control over the data? Like, do you give consent for it being shared, and for who it's shared with? If there's errors, can you get them corrected? Is there a delete button, or does the data just linger around in a database forever? And then an important part of protecting privacy is that if you have laws and rules, who's enforcing them and how are they enforced? A really important thing you hear about in privacy law is private right of action. That means that an individual has a right to sue if a law is broken or if their data is being shared improperly. So that's sort of like the strongest enforcement component you can have. But in some cases, laws have things that are less than that. There's a lot of existing laws and policies. So we have the Student Online Privacy Personal Protection Act listed here, SOPA, and that is a state law. There's laws at the federal level. Some are specific to schools, like the Family Educational Rights and Privacy Act. So that's called FERPA, and you've probably heard about that. One that also is important for ed tech is COPPA, Children's Online Privacy Protection Act. But That doesn't apply to everything that happens in schools. It's only for children 13 and under. FERPA and then the kind of the state level equivalent, ISRA, the Illinois School Student Records Act, are really strong privacy laws, especially ISRA. It does have a private right of action, but they were written in like the mid 70s. There wasn't it wasn't a time when there was no digital data, but mostly things were on paper. They were in file cabinets, and even digital data, things were held by the school, and it was very much like the school could grant access or not. Now, especially with digital data, it is not really, in possession of this. The school does not have possession of it, and it might be in the cloud. It might be on server farms very far away. And so part of the reason that there's been a push to update, especially at the state level, these state privacy laws, is to kind of fill in the gaps where FERPA and ISRA aren't super clear on, especially parental control. If you want to actually make a request to see your child's data, and it's being held not by the school, but by a third-party company who really has permission to grant you that. So I see you mentioned about HIPAA. HIPAA really does not apply to schools. And so even stuff like medical data that is under HIPAA in other situations is really not regulated or protected by it at the school level. So even though it's maybe the exact same information, if it's being held by a school, it's not covered under HIPAA. So I think it's like, which is kind of, I think, surprising to people a lot of times. So here's like kind of a big overview of what is in SOPA. I will highlight a couple things on the next couple slides. I think it's important to know that this bill in 2019, which was a big amendment to the bill that originally passed in 2017, really had a lot of opposition. The bill in 2017 was really a negotiation between a lot of tech companies and then school management organizations like principal association, administrators, school boards, but it didn't really, parents were not at the table, families were not at the table. And so there's some big loopholes, but there was also some areas that just weren't even discussed. So breaches, the word breach didn't even appear in the original SOPA. The word parent doesn't appear because it had nothing to say about parents and access to data. And it really also didn't talk about what school duties and prohibitions were. And so there was stuff missing, and it's especially because there was not a lot of discussion with parents. So we pushed to have some of this stuff fixed, and that's really the stuff I'll talk about next. I do see a question here from Ronald Greenberg. I'll talk about the CPS, especially the CPS issue at the end. And it's not so much that CPS is giving this overly strict interpretation of the law. In some cases, I think they're just misinterpreting it altogether. And they have some the way they're working with operators or potential operators is very unhelpful. And so operators are just walking away because they don't want to negotiate a contract with CPS. And it's really, I think the issue is that other districts have managed to sign contracts that are compliant. So it's definitely possible. And so it's really an issue with district administration and not so much the law, but it's really a problem. So I'll talk about that at the end again. So what does SOPA apply to? Just because there's an app that's being used in school and might have data about a child does not mean that actually necessarily it's being regulated by this law. So covered information is sort of like the data that's being protected under SOPA. That has to have it either has to be personally identifiable or it has to be linked to something that's personally identifiable. So de-identified data where you've kind of stripped out the identification part, that is not protected by this law. Also, if there's information that's already publicly available, that's not protected by the law. The SOPA only applies to software and sites and apps that are being used for a K-12 purpose, which means that it's a use that's being directed by the school. So you might be using some ed tech app at home, but if it isn't something that a teacher assigned, that's not going to be covered by SOPA. And it does not just cover students using ed tech. It also covers any kind of sort of back-end stuff. So administrative software or the student information system that teachers are using to enter grades, those are also covered. One thing that I think is a big difference from before is that an operator is not just someone who's selling software to the school district or the school, it's also freeware. And so just because your school isn't paying for it does not mean that it's not going to be covered. And the other key thing here is that it has to be a site or service or an app that's been marketed or used or designed for K-12 schools. So general purpose software it's not covered. So that leads to some kind of surprising things where something like YouTube, if a teacher tells your kid to use YouTube in the classroom, even if your school has a contract with Google and Google is an operator for something like Google Docs or for Google's apps for education, YouTube is not K-12 specific software. And so there could be data being collected by YouTube that is not covered information, and it's not really going to be regulated by this law. So that's kind of a big loophole. And in some cases, there's probably some issues with that, but I think it's something to keep in mind as you look at this. The sort of key to how SOPA is protecting data is really this transparency aspect. So schools now can only share covered information if they have a written contract with an operator. And those contracts have to have these very specific requirements. And so that's the way the transparency is essentially made possible. So contracts have to actually, only certain employees can enter into a contract. There has to be a specific policy on that. The contract has to be made public. And the contract actually has to say which data elements are being shared, if there's some subcontractors that they're being shared with, who those are, what services are actually being provided. And so you know what the data is being used for. And the contract also has to say that if there's a breach, the operator has to tell the school within 30 days. So that is something new that was not in the previous version of the law. The control aspect, this is also new now. And really, it's making sure that parents have clear access to their child's covered information. So parents now have a very clear right to receive a copy of covered information, to inspect it, to request corrections or deletions, and also a right to be notified about breaches. And schools have to really make a clear written policy on this so parents know how to exercise these rights. So what can you expect from your school right now? They've had 2 years to prepare and to get into compliance. It's still a major project because there is just so much software in use, and before it was basically unregulated. So, teachers could find an app online and just ask kids to start using it essentially. And there wasn't much control from the school level or the district level of this. So schools or districts, if your district is fulfilling these things, it doesn't have to be fulfilled on the school level, should have an inventory of all the data elements they're sharing, who they're sharing them with. They should also have a whole inventory of contracts with operators, and you should be able to see those contracts. And they should also now have a list of breaches if those breaches are affecting a certain amount of students. And if the breach happened after July 1st, 2021. So they don't have to have a historic going back list. And they should have clear policies explaining what I said on the previous slide. And if your child's covered information is breached, you should find that out within 30 days of when the school learns of that. So that means a breach can happen, an operator has 30 days and that to tell the school, and the school then has 30 days to tell the parent. And just like before, operators in the original version of SOPA could not sell, rent, lease, or trade covered information. Now schools are also prohibited from that, which seems like common sense, but can happen in some circumstances. So how is this rollout going? It's really, I think in a lot of districts, it's been work, but it hasn't been overwhelming. And that has happened in part because the majority of districts in Illinois have joined something called the Illinois Student Privacy Alliance, which is a consortium. You can join it for free as a district. And when one district in that consortium signs a contract with an operator, you can then make use of that same contract. And so they have some very kind of basic generic contract language that school districts can build on. And then once there's one signed contract, everyone can use it. So especially if your district is a member of that consortium, you can go to that website and find, your district on there, find the list of stuff that's been approved, and then see right into the contract and see what's being shared with that operator. I have not seen as much on district websites, this list of data elements that are being shared. And I think it varies how clear the instructions are for parents in terms of accessing your kids' data. So that is probably still a little spotty. This rollout has not been uniformly smooth all over the state. We are definitely hearing from teachers and students in Chicago Public Schools that the rollout of SOPA has not been great. CPS did not choose to join that consortium. And so there is a lot of software elsewhere in use in the state where districts have managed to sign a SOPA compliant contract with an operator, but CPS is telling students and teachers that they can't use that same software. And yet there's also still software in use in CPS right now that is not listed on the district's list of approved software. It definitely contains a ton of student information. And an example of that is the basic student information system in CPS. Aspen is not yet on the list, and it has a huge amount of information. Pretty much every student in the district is in Aspen, certainly everyone in a district-run school, and it clearly should be covered under the law, and it's not there yet. And so I really don't know what's happening that the district had 2 years to comply and didn't manage to get their sort of like key student information software in compliance with this law. It's very concerning. And yeah, it's a big problem. The CPS policy, so CPS has a policy for the law, and then they also have guidelines. The new policy does have one really good thing in it. It strengthened it a little bit over the state law because students are not allowed to sign contracts with operators, which sounds crazy, but it was happening, especially with the College Board to use their website. Students were being asked to sign a legal agreement with the College Board separate from the legal agreement that the district already had with the College Board. So now that is not going to happen in CPS. It's been prohibited. It's in the new contract that the district has with the College Board. It is probably still happening elsewhere in the state. So that is problematic. So a question here from Joseph in the chat about should CPS join the consortium? I mean, I don't really see what the big downside is, except for that. I mean, if you look at the contracts, I do have some questions about some of the contracts, but from a parent advocate perspective, it's actually really helpful because if you see a contract in this consortium and you're like, I think that looks bad, they haven't listed enough stuff, it's not clear enough in the data elements, you could push against that and fix that for, kids throughout the state. And I don't know for sure, but it doesn't look that restrictive. So I think you can join the consortium and you can still sign some individual contracts with operators if you want to. You aren't forced to use the consortium's contracts. So I don't know. They have a lot of, the CPS law department at this point has 97 employees. They've been growing every year as the district has made cuts elsewhere. And I don't know what the justification is to not, save money and time and preserve access to software that people really want to use in the classroom. And looks like the vendors, are able to be in compliance, and yet it is not available. And it's really tough. And so I think, especially as there's teachers and students out there who want to get this fixed, it's going to take some advocacy. And it's sort of just another issue where we have this like exceptionalism in Chicago that shouldn't really be there. And it's a solvable problem. But it's going to take some pushing, I think, and organizing to stop it. And finally, what's still missing from SOPA, the law, the 2017 law was better than not having a law, and the 2019 law has a lot of stuff that we were really happy to have in there, but there's still things that are really not there. There's very few prohibitions on surveillance, like the things that like Go Guardian I was talking about before, surveilling what kids are doing online when they're not even at school. Parents are rarely asked consent for sharing data. Like at best you might be notified, but you certainly aren't going to be asked if you really want to share that data. And if you say no, or you try to opt your kid out, you probably have very few options. So in a sense, your child's having to hand over data to get an education in some cases. The enforcement mechanism in the law is really just the Attorney General's office. There's no private right of action in SOPA. And so we know that there's some operators that are violating the law, such as the College Board, by licensing, AKA selling data, but no one's stopping them. I'm also seeing some stuff about breaches that are happening, and it's not clear if they're getting reported in compliance yet, like they should be. And there's still a lot of loopholes in the law in terms of commercialization and ways to profit from your access to student data as an operator that are not really restricted at all. So there's definitely room for more advocacy, just like on the play law, there's room for advocacy in improving, say, how lunchtime is regulated. And so we have a little ad here at the end to ask for your support again. And I will hand it back to Jen and Catherine.
Thanks so much, Cassie. It's a lot of information to absorb. And, please, if you have more questions, we have a few minutes now at the end. You can add those to the chat. I think there's a few more to go over. Yeah, I just wanted to say to everyone, these important new laws wouldn't have passed without active, involved, pro-public ed folks like you all working with and supporting us to move them forward. I mean, we are the only pro-public school parent voice that can do unlimited lobbying in Springfield. And unfortunately, there's opposition to many of the issues we support and know are important to public ed. So we have so much more work to do. Even tonight, there's some new suggestions of things that we could look into and work on. But we really need sustainable funding to keep it going. So we hope that you'll consider pitching in tonight. I'll drop a link in the chat if anyone is interested. Once again, we appreciate everyone coming tonight, and I'm going to turn it over to Catherine to follow up on some questions that we didn't get a chance to answer.
So I think Cassie touched on the questions that we had, but I would say it would be good to circle back to the first one, which was about Chicago Public Schools being overly strict in their interpretation of SOPA and denying students access to curricular materials. And maybe this has to do with their misunderstanding of SOPA and their refusal to join the alliance to create contracts to make that work. But Cassie, do you want to further illuminate that question?
Yeah, I mean, I think some of it really is some misinterpretation issues. So I was seeing that some student journalists were being told that they couldn't use like Adobe InDesign. And that's a case where like that is general purpose software. Like I find it very surprising that they have some special K-12 designed and marketed version of that. And so that's something that SOPA shouldn't even apply to. So for the district to say that you can't use that now, I think is very surprising. And even, anything that like is in use in the rest of the state that makes it clear that it is possible to sign a contract with a vendor that is in compliance. And so I think there's going to be some advocacy that's needed. And so people can you know, you can go to board meetings, you can get office hours with board members. And I think we're going to try to especially coordinate some of that with people who are running into this, and that's both teachers and students. So if you know of a specific software that you're being told you can't use, please get in touch. We'll try to connect people. And yeah, there's not, I mean, there was 2 years to get this rolled out. The CPS policy is very similar to the law. So that's not quite the issue, but if you look at the CPS guidelines that they've added on top of the policy, they're almost impenetrable in some ways. And I don't really know what they were trying to do with those. And I think that's probably the point at which potential operators walk away because they don't want to deal with that. And the weird thing is, I think a lot of it is kind of tied into like Aspen and how Aspen is being used, and Aspen itself is not in compliance yet. So it's a real mess, and people should be angry that it's constricting, you know, their educational options right now. So yes, I mean, we've been working to try to make sure that the CPS rollout is good for a year now. That provision to prevent students from being forced into contracts was added basically because of our advocacy. So I'm certainly happy to try to get the district to do the right thing here. And, you know, it's kind of the same on the recess law where they specifically, the central office specifically told principals they don't have to be in compliance yet. And it's very frustrating that we pass laws and then we have districts that just say, we don't really want to comply. And yeah, I think you would think that joining that consortium could fix stuff. And I do not understand why that hasn't happened. One thing that we'll also encourage people to do is really to talk to your representatives and senators about this, because, you know, it passed with good margins. People wanted this to happen. And so if the district is interfering with compliance and implementation, that's a real problem, and people's legislators need to hear about that.
I think also we wanted to hear, or embedded in a question about their refusal, is what are the misinterpretations? Or I know you and I have met with board member and met with the legal team about SOPA. You know, can you talk about CPS's misinterpretations or the guidelines and how they're sort of missing the boat?
Yeah, I mean, I think part of it is like looking to see like this journalism software. When I looked at the student newspaper online, it's called SNO, that student newspapers around the state, including college papers, are using. So that's something where you're like, well, if it's not really just a K-12 application, maybe the law actually shouldn't be applying to it. And then the other question is, if the data that's being entered into there is then published, that data is no longer covered. So for the most part, you know, SOPA doesn't have anything to say about that software. So I think there's questions there about applicability that should be answered, and, you know, that, you know, parents and teachers and students should be demanding answers from the law department on. The guidelines thing is so like weird and draconian. I can share a link from, or I can send out after this, I can the letters that we've exchanged with the CPS law department and IT department on it, but it's so weird and crazy that it's even hard to understand. Like it's hard to sum up. And we just had a ton of questions when we were trying to decipher it, about like how they're categorizing different types of software and different types of data entry. And they were making these weird distinctions about whether, you know, a child is entering the data in the classroom or the software is being used in the classroom versus somewhere else, which the law doesn't say that there's any differences there. And so it's very, those guidelines are really tough. And I suspect that a lot of the issues with operators are coming from those, actually. And I don't know if the issue is in the IT department and their ideas about how things are supposed to be working, or if it's in the law department and they just can't get these contracts signed. But either way, it's really a mess, and it clearly does not have to be. I think that's the concerning aspect.
Well,
I
and
think
if they join,
something that I noticed in these meetings with CPS IT is they're so focused on top-down centralized control. They're trying to create a master list of software that's usable and distribute it to 500 to 800 schools. And it's just, they're just so obsessed with district control that I think that's really one of the things that's getting in the way. The way that the IT and the legal departments talk, it's very strange.
Yeah, although
well,
that's a really solvable problem, because you can see that in this consortium, there's, 790 schools, or even more than that, because it's districts. And, there's more than 27,000 app or contracts that have been signed. So it's, they are right to make sure that it's controlled at a district level, what software is in use, but they are still really messing it up in a way that is very special.
we also had another sort of follow-up question. Thanks for indicating the misinterpretations, but there are also issues with other software that is specific for K through 12. And sort of what is the mechanism to fix that?
Yeah, I think
Or
it's
is
getting
there?
a good list of stuff that people have been using, and then especially showing that contracts exist for that in the consortium, I think will be a very convincing argument that it's not impossible to get a vendor to sign a contract for this stuff. And I think, making sure that basically legislators are hearing that the rollout of this is a mess. And I don't think they probably have heard that much yet. And so I think that's really important. So yeah, I would be happy to talk to some of these computer science teachers, and, it's, yeah, the transparent, I think it's just unfortunately like a typical CPS botching of something that should be good, and they're not doing it well. And I think it's fixable, especially because there are clear solutions that are literally online that everywhere else in Illinois is using. And so you can be like, why are we not doing that? And I don't think the law department or the IT department has good answers to that. So, yes.
Are there places that people can go? A teacher could go and say, look, I can see that this is software used throughout the state that you're denying me access to. Like, who would they contact in CPS to make the case?
I think it'd be better if they organize together, so especially if there's a group of teachers, I think, making a list and showing that there's contracts for these same apps elsewhere, and, signing it as a group letter from a bunch of teachers would be helpful, and directing that towards the Board of Ed, and then also making sure that legislators are getting a copy of it as well. And, I've been reaching out to a particular school on this, to students. And so I'm happy to try to, coordinate that more broadly, because it has to be done.
And since CPS is not in the consortium, how do we get access to the list of contracts?
You can see that's the kind of handy thing about that consortium, is that it's all online. Let me put the link in the chat. And the link will be, we're going to share the slides too, and that will have the link as well. So let me put it here. I mean, it will sort of make you weep, because you'll probably look up most of the stuff you want to use and it'll be in there, and you'll be like, why? So, I mean, it's very frustrating because like, you know, people are like, my God, what is this law? This is terrible. And it's, you know, it is clearly workable. Most of the law comes from language that has already been implemented in Connecticut and Colorado, and New York now has very similar constraints. So it's very workable and doable, especially once the initial rollout happens. But clearly, it's also something you can mess up and have a lot of problems with. So yeah.
So I think that's the questions that we had for the most part. So thank you very much for coming. And as always, we here at Illinois Families for Public Schools love your participation. We'd love you to join us and donate or join us in advocating. So have a great evening, and hopefully we'll see you again soon.
Good night. Thanks, everyone.
Thank you.